in setting charity. You won't be shown on the screen because this is webinar format and we'll only see our panelists, but we will stop recording when we get to the Q&A session. There are not any fire alarms where I am, but please keep an ear out for these wherever you are. Please do respect confidentiality, but also feel free to share the learning from this session within your organization. And you'll be able to access the YouTube video as well after the session, which you can, of course, share with your colleagues. You'll notice that closed captions or subtitles have been enabled. To turn these on or off, please click on the CC button at the toolbar at the bottom of the screen. If you click on this, you'll be able to choose show subtitle or hide subtitle. Okay, just one more slide from me. So just a little bit of background on before I hand over to the Withers team on why we have chosen to run this session. So some of you here might have joined us on our previous 2 sessions on setting up a charity and choosing your legal structures, which were very popular webinars. Following on from that, we decided to take a deeper dive into one of the top areas that we have for inquiries here at NCVO, governing documents. We know that both writing and amending your charity's governing document can feel confusing and complicated. So we're really trying to clarify some of the big questions that you have around that. Some of you may be aware that the Small Charities Coalition, which did a lot of work in the charity setup space, closed earlier this year, and NCVO, along with our partner, the FSI, have taken over the help desk, the charity setup tool, and some of the other projects that SCC ran. And we're very keen here at NCVO to carry on SCC's legacy of supporting small organisations in their early stages, as well as being committed to supporting charities throughout their lifespan. And I'll give you a little bit of information at the end around how you can access our help desk. So just before we kick off the session, we're going to launch a quick poll just to find out about the types of organisations who've joined us today and why you're here. So that should come up on your screen. So if you could let us know the reason you're attending this webinar. Is it because you're writing your governing document for the first time or amending your existing governing document? So we'll just give it a little bit of time for everybody to participate. And yes, the recording will be available afterwards. Just seen a question pop up. If you haven't participated in the poll, if you could just submit your answer if possible. The recordings from previous sessions are on our YouTube channel, and we will give you the links to those in the follow-up email. Okay, we've had 88% people participated, so just to reflect on that, I think we'll end that poll. So we've got 15% of attendees here because they are writing their governing document for the first time, but an overwhelming 85% who are amending their existing governing document. Interesting to see. Okay, so without further ado, I will hand you over to the Withers team.
Thanks, Amy, and good morning, everybody. My name's Chris Priestley. I head up the charities team at Withers. So all of my job is working with charities or people working with charities. As Amy said, we want to try and make this as helpful and practical a session for you. So if we just move on to the next slide. It is a complicated area and we get asked lots and lots of questions. It's a big part of our practice is helping charities navigate their way through how you deal with amending and writing governing documents. But there is a lot of help out there, and I hope that the recording of this session will be a useful reference point for you going back through it. So in terms of what we're going to cover today, just a very quick recap on what we mean by governing document. And then we thought we'd split the session into two sections. The first section about writing your governing document. Now I know we've got a sort of 15% of you are looking to do that. And actually what we cover will also be useful for the other 85%, because writing your governing document, the drafting will be useful as well if you are going to amend that. So we'll just do a quick recap on what a governing document needs to look like, what you need to have in there. Where you can find examples of help and resources in terms of doing that. And then the second section, which is the meat of the presentation, will be how you go about amending your governing document. Why might you want to amend it? What are the sort of common reasons for doing so? And then looking at the sorts of changes you can make, without having to get the involvement of anybody else. And secondly, how do I then go about making those amendments, and what are the rules around that? As you may be aware, the law is actually going to change in this area. So we have a new Charities Act. It came into force, or it received royal assent in April. The good news is that the new rules around changing governing documents aren't going to come into force anytime soon. It's at least a year away before that happens. But I will talk a bit about what those changes are. And I think the key takeaway is going to be, if you are thinking about changing your governing document, it will probably be simpler to do that before those changes come into effect. So this is a very good time to be thinking about that. And then, as ever, we'll try and leave lots of time for questions and answer any points or deal with any comments that you have. And as Amy said, at the end there'll be a list of useful resources that you can refer to. So let's kick off. Hannah, do you want to take the next slide?
Thanks, Chris. So hi, everybody. I'm Hannah. I'm an associate in the charities team at Withers. So just a very quick recap. What is my governing document? Your governing document is the piece of paper that sets out how the organisation should be run and how the charity trustees need to be exercising their powers and what powers they have. The governing document will be called something different depending on the legal structure of your charity. So if your charity is structured as a company, it will have articles of association. If it's a trust, it will have a trust deed. And if it's either a CIO, which is a charitable incorporated organisation, or an unincorporated association, their governing documents are referred to as constitutions. You or one of your fellow charity trustees should be able to locate a copy of your governing document. This might be a sort of hard copy somewhere, or even an e-copy online, or as a computer file. However, if for whatever reason you're sat there thinking, I don't know where my governing document is, if your organisation is a registered charity, you can actually contact the Charity Commission and ask them for a copy of the document that they have on file. They have an inquiry form online that you can do that. If you're looking at this slide and wondering what the legal structure of your organisation is, or wondering how to set up a charity, as has already been mentioned, we have done a couple of webinars previously for NCVO that have been recorded and are on the NCVO YouTube channel on legal structures and how you work out what legal structure your charity is and how to set up a charity. So those are available, and those resources will be available at the end of the seminar as well.
Great, thanks, Hannah. So morning, everyone. I'm Amy, and I'm a senior associate in the charities team at Withers. So to kick off, what do you need to include in your governing document? Now, your governing document, as Hannah mentioned, is the most important document for your charity, and it contains all the key rules which govern how your charity operates. Now, it's a legal document, and the type of governing document will depend on your legal form. Now, whilst different types of governing document are written in slightly different ways, depending on how you're structured, and will contain provisions that are specific to that legal form, there are some key provisions which all modern governing documents should contain, and we've listed most of these on the slide. Now, I know most of you here are looking at amending your governing document, so this will be a really useful reference point when looking back at what you've got in your governing document. We do come across quite a few older governing documents which don't tick all of these boxes, and that might be something that you want to look at introducing. So first on the list, we have your charitable objects or purposes, and we use the words objects or purposes sort of interchangeably, really. It is the most fundamental provision in your governing document, as all of your charity's activities must be to further those objects. And in order to be a charity, those objects must be exclusively charitable for the public benefit. And as Hannah mentioned, you can find out more about that in our previous video on setting up a charity. Objects must be drafted in a particular, rather legalistic way. The Charity Commission has published some really useful guidance on drafting charitable purposes, which you can find on their website, along with some example objects for charities operating in different areas. Now, whilst your objects must reflect what your charity is set up to do, where possible, we would recommend using the wording from the Charity Commission's guidance and examples, or looking at the objects of existing charities, and Hannah will show you how to find those shortly. When setting up your charity or looking at amending them, it's really important to get the objects right. As we'll come on to later, it can be very difficult to change your objects in future. So if you are writing objects for a new charity, you should think about how your charity's work may develop in future so that you don't have to change them again. And if you are looking at making amendments, think really carefully about how you're amending them and what flexibility you might need. Now, your governing document will set out your charity's name. There are some words where you need permission to use that word in a charity's name, and some of the common ones we find for charities are foundation, fund, charitable, royal, hospital and council, all of which will need some form of consent. You should also check that another charity doesn't have the same or a very similar name. And whilst not a legal requirement, many household name charities will go by their acronyms, so RSPCA, RNIB, and even NCVO. So if you are planning on using an acronym, you might want to just check that another charity isn't already using that one to avoid confusion. So next on our list is powers. Now, the powers provision sets out what the charity can do in order to further its objects. For example, borrow money, make grants, provide housing. If you use a model governing document, which Hannah will explain about in a moment, the model should include a comprehensive set of powers, but this is something you might want to look at if you are amending an existing governing documents. You're also likely to have a sweep up provision. This is the power to do anything else which is lawful in order to further the charity's objects and is really useful to include. Next up, we've got trustees. Your governing document won't set out the minimum number of trustees, and it may also contain a maximum number. This is one of those provisions that we frequently are asked to amend. It will also set out how trustees are appointed. So some trustees are appointed by the trustees themselves, others are elected by members, or they might be nominated by another body. And in many cases, you might have a combination of those. It should also set out the term of office for trustees. The Charity Governance Code recommends a maximum of 3 terms of 3 years, but you are free to set other limits if you would like. Some charities may also provide for retirement by rotation, where each year a certain percentage of the board resigns, and that's often one of the provisions that we are asked to amend. Trustee decision making is also important. The governing document will set out the number of trustees who need to be present at a meeting for decisions taken to be valid, and we call this the quorum, who will chair trustee meetings and whether they have a casting vote, whether decisions can be taken in writing, so written trustee resolutions, and whether meetings can be held virtually. The next one we've got is application of income and property. To be charitable, the governing document must provide that the assets of the charity can only be used to further the charity's objects and not for the benefit of the trustees or members personally. This means that the starting point is that trustees must not receive any financial benefit or payment from the charity. The governing document will set out certain very limited exceptions to that rule, usually the payment of expenses for acting as a trustee, so to travel costs to meetings, the benefit of trustee indemnity insurance, and for providing goods and services to the charity, subject to certain controls. However, trustees cannot be employed by their charity without express authorization, and members of a charity are not entitled to dividends or other payments from profits. Trustees have a duty to manage conflicts of interest and loyalty. This is to ensure that they act solely in the best interest of the charity. Your governing document will normally set out how conflicts are identified, declared and then managed, for example, by requiring conflicted trustees to leave the meeting and not have a vote. Finally, your governing document must set out what happens if the charity were to close. This is sometimes referred to as dissolution or winding up. In particular, it will set out how a decision to close the charity will be taken. Usually this requires a special vote, and how any surplus assets are to be applied. Now, those leftover funds must be applied for charitable purposes, and usually the governing document will provide that they are transferred to another charity with the same or similar objects. So now over to Hannah.
So as you can see, there's a lot of information that needs to go into your governing document, and luckily there are some really brilliant resources out there that set out sort of those key provisions called model documents that include some suggested drafting. The Charity Commission has model governing documents on its website, which are now in a more easily amendable Word format, and NCVO also has a page of useful links to sample model documents. It may be that depending on the type of organisation you're setting up, if it's affiliated with a larger national charity, for example, or an umbrella type organisation, they may have model documents that they suggest you use or prefer you use that they can provide. So please don't feel that you have to go home and write all this down from scratch. There's resources out there that can influence and inform your drafting. What I'm going to do now is I'm just going to show you where you can find those bits of drafting online. So specifically for bits of your governing document like charitable objects, again, as Amy mentioned, the Charity Commission has put together some suggestions for charitable purposes that can be used for different circumstances. So they've got example documents for animal charities, or for charities setting up community centres, or for those advancing education. So you can find what you're looking for there. However, we do stress that depending on the structure and complexity of the organisation, and depending on what you want to do, please be careful when amending the model document. Some of the provisions are there for a reason, and if you do think that you need assistance at some point, sometimes it's worth to see if somebody can help you. So I'm just going to come out of the PowerPoint, and I am going to show you where you can find these documents online. So bear with me, here we are. So this is the register of charities. So there's an email address up here. And one thing that you can do, as well as looking at model governing documents, is see what other charities out there have done, already registered charities, so you know that the Commission has looked at their objects and approved them. So say, for example, we wanted to set up a food bank. So what we're actually going to do is just do a general search here. And as you can see, I've already looked at the Weston-super-Mare Food Bank to check that what their governing document says. And so you go into the charity, you click on this section here that says governing document, and it gives you a little summary here of its charitable objects. And while obviously not everything will be relevant to you word for word, it's a really good indication of what you can say and what you can use, and a good basis. Two other websites I'm just going to show you very quickly. Here is the Charity Commission website. So it's on the gov.uk website for the model governing documents. So we've got a CIO, a charitable incorporated association, just a normal charitable company, all kinds of things here. So you find the structure you're looking for, and then what that does is that sets out some key bits of drafting. And then finally, we have the example charitable objects I was talking about. So as you can see, they are arranged here by topic: advice and counselling, carers, community transport, whatever you're looking to achieve. It's possible to find something that you can adapt online. So let's go back to the slides. Fab, and I'm now going to pass over to Chris. You're on mute, I'm afraid, Chris.
So sorry. Thanks, Hannah. So in terms of looking to amend your governing document, we get asked by lots of clients to help them do that, and we try and signpost the resources that are available. And thinking about the sorts of reasons that people come to us as to why they want to change the governing document, it may be that the charity was set up a long time ago, and that the way in which the objects are encapsulated uses out-of-date language. And that's important if you're applying for grants and you want to share a copy of your constitution to funders, or you put it on your website, or if it's a company, it's publicly available in terms of the governing document. So it may be you just want to update the language, but it also may be that the purposes for which you were originally set up are shifted. You had to think about doing things slightly differently. So you may want to change your objects in some way to allow you to do something that you can't do under your existing governing document. It may be that you just have procedural matters, administrative matters around the appointment of trustees, or how meetings are to be run, quorum provisions. You just need to look at, you want to update those. And I always think, if you look at your governing document and you go through it, does it actually accurately reflect what you do in practice, what you're set up to do, and how you work? And can you make life easier for yourself? And I think that's often the common reason for making some changes. The Charity Governance Code, it's good practice. I know people like me and Hannah and Amy enjoy looking at legal documents. You probably don't enjoy it as much, but it's important to make sure that your governing document is a good framework. And if the things in there that don't work for you, then it is a good idea to change them and make the administration of the charity as unburdensome as possible. So the other reason we often see is also putting in gender neutral language, for example. People are looking to do that more and more for good reason. So lots of reasons as to why you might want to change your governing document. Amy, do you want to just talk through then how you go about amending?
Of course. So when it comes to technically how you make those amendments, the starting point is always to check the provisions in your governing document, as it may be that you have an express power of amendment, sometimes called variation. Generally, administrative changes can be made to a charity's governing document without the Charity Commission's involvement, and this would cover changes to the appointment and number of trustees, the charity's name, or how decisions are taken. In contrast, the Charity Commission's consent is normally required if you want to amend your objects, change provisions on trustee benefits, or what happens if your charity closes. And Chris will come onto that shortly. Now, making your amendments really does depend on how your charity is structured. So if you are formed as a company, under the company law, the members have the power to amend the Articles of Association, not the trustees. Members of a CIO, a charitable incorporated organisation, also have a similar power, and your CIO constitution will contain specific provisions on amendment. The governing documents for unincorporated association and charitable trusts will typically contain those express powers of amendment I talked about, but if not, there are specific powers set out in the Charities Act which can be used. And as Chris mentioned, as a flag, these are changing, but this is the position now as of November 22. So Section 280 of the Charities Act sets out a power to make administrative changes to a charity's governing document by resolution. And this power can be exercised by the trustees, or where you have a separate body of members, so an unincorporated association, by a vote passed by 2/3 of the members. Section 275 also allows smaller unincorporated charities to amend their objects without Charity Commission consent. So unincorporated charities, this is only available to trusts and unincorporated associations. So if your annual income is below £10,000 and the charity does not hold land which must be used for a specific purpose, so it's sometimes called functional land, specie land, or designated land, you can amend the objects without the Charity Commission's consent. And there are several conditions to this. So first of all, the trustees consider it is in the best interest to do so. You shouldn't be going down this route if you don't think it's the right thing to do. The new objects are as similar as possible to the objects which you are replacing. So if you are a food bank, you can't suddenly shift to fund medical research. It needs to be as similar to what you're doing at the moment. and the new objects are exclusively charitable. Once a charity, you are always a charity. Now, the resolution must be passed by not less than 2/3 of the trustees, and a copy of the resolution must be sent to the Charity Commission with a statement of reasons for passing the resolution. If you have a members, the resolution must also be passed by the members. Provided the Charity Commission doesn't object to the resolution, it will take effect 60 days after it's been sent to the Charity Commission. Now, this statutory procedure, as I mentioned, is set out in section 275 of the Charities Act, and so we refer to it as a section 275 resolution, and we'll probably use that shorthand again in that presentation, so that's what we're referring back to. So over to Chris to talk about those situations where you do need the Charity Commission's consent.
Thanks, Amy. So I'm conscious that there was a lot there, but there will be more information provided as part of the follow-up to this. So we've looked there at some changes that you can make yourself, that you don't need to involve anybody other than internally in the organisation. But there are certain things where you do or you're not able to make the change, or it isn't effective without getting the permission from your regulator, the Charity Commission. And that's there for good reason, because the Charity Commission wants to make sure that what you do still entitles you to retain your charitable status. So that they have a role in ensuring that they are comfortable with what is being proposed. So currently, the need to get Charity Commission consent, it goes back to what we said at the outset. It will depend on what your legal form is, what your structure is. And so there are different rules for charitable companies and CIOs as compared to unincorporated charities such as a trust or an unincorporated association. There are yet another set of rules for charities that are governed by a royal charter or an act of parliament, but we're not going to cover those today because I think most of you will be either a charitable company, CIO, or an unincorporated charity. So let's start with the incorporated charities. So that's charitable companies limited by guarantee and CIOs. Now, what we have there is something called the regulated alteration regime. And that is, regulated alterations are those changes that you must get the approval of the Charity Commission first before they can become effective. And there are three types of regulated alteration. Any amendment to the charity's objects, and that is any amendment. So even if you just simply are updating the language in the objects clause, that is regarded as an amendment to the objects. You might still be a charity that relieves poverty and you just want to change some of the terminology. Any changes like that to the objects do require you to go to the Charity Commission. So that's the first category of regulated alteration. The second category is if you want to change what happens on the winding up of a charity. Some governing documents say if this charity is wound up, all our assets will go to a named charity, and you might want to change that. That's far less common, but it is another one that is a regulated alteration. And then the other one is where you want to make any changes in relation to the provisions in relation to payments to trustees. Now, that could be expenses payments, or in certain circumstances, it is possible to get the consent of the Charity Commission to allow a charity trustee to be paid for being a trustee. So if any of those trustee benefit provisions are going to change, then that's something that you need to involve the Charity Commission with. Now, the important thing is, it's the right thing to do is to get that permission from the Charity Commission first. There's no point in putting the resolution to members to approve it if the Charity Commission then come back and say, that's fine, but you need to change X and Y, because then you just have to go back to the members. So come up with your proposal. What is it we want to change? Why is it we want to change it? And then approach the Charity Commission. Once the Commission is comfortable, you can then put the resolution to the trustees and members to get that approved and made effective. For unincorporated charities, so that's charitable trusts and unincorporated associations, the rules are slightly different. So you'll always need the Charity Commission's consent to amend the provisions around trustee benefits. So if you want to pay trustees or you want to change the benefits they're entitled to. And you'll always need to get the Commission involved. If you hold property, and it may not be that very many of you do have this, but if you have what's called permanent endowment, that is property where you cannot spend the capital, but you can only spend the income. If you want to change the rules around what you do with that, then that's something you need to involve the Charity Commission with. Again, that's a very probably extreme example. And then the final change is that if you want to change the objects of the charity, then unless your income is below £10,000 and you can meet certain tests, then again, that's something you need to get the Charity Commission to approve. And in the case of unincorporated charities, the way in which the Charity Commission gives its consent is they do something called making a scheme. And that is a scheme, which is another word just really for a constitutional document which will amend your governing document. Now, as Amy mentioned in her section there, if you're a charity that has annual income of less than £10,000 and you don't hold any special type of land or anything like that, then you can rely on the statutory provisions, so that there is a legal provision in the Act that allows you to amend your charity purposes. Conscious that limit is relatively low, so if you do have annual income over £10,000, then you must get the Charity Commission's approval to amend your objects. And as Amy said, if you change your objects, the important thing is they've still got to be exclusively charitable and for the public benefit. And it would be unusual, I think, for a charity to radically change its objects. So if you're a charity that is working in the field of health, then if you were suddenly to move into homelessness, that would be quite challenging to get that through the Commission. It may not be impossible, but usually changes are fairly modest, or it's adding another object to your existing objects and expanding what you're able to do, and that's certainly the sorts of things that the Commission will be comfortable approving. Going back to the scheme, what the law says is that you can amend your objects, and it's usually, as I say, to be a similar, CPRE is the word that is used, as similar to the existing objects of the charity as that can be. And that's because the law says if you want to change your objects, then usually you've got to be able to justify it on the grounds that actually, for some reason, the original purpose or one of the original purposes for which you were set up to further can no longer is either met, the need is being met, or there is some other circumstances that has changed. So, for example, you are set up to provide shelter for those who are homeless, but you also then want to provide benefits advice and probably do more of that. So that's the sort of reason that expanding your objects or changing them to reflect the need that you are seeing, that's perfectly sensible, perfectly reasonable, but you do need to bring in the Charity Commission on that. Okay, Amy, do you want to take the next slide?
Thanks, Chris. So we're now going to look at how you amend your governing document. And as we keep saying, it really depends on the legal form your charity takes. So whether it's a trust, a company, a CIO, or an unincorporated association. So if you are a trust, the trustees can agree to make the changes at a trustee meeting. Now, depending on the wording of any express power in your trust deed, those changes may be made by documenting them in a resolution passed at the trustee meeting, or you may document them in a deed of amendment. This is a legal document setting out the various amendments which you are making to the trust deed and must usually be signed by each of the trustees. Where you are applying to the Charity Commission for consent, as Chris said, the Charity Commission will make a scheme which then amends your governing document for you, so that will form part of your governing document going forward. If you are an unincorporated association, the decision will usually be taken at a members' meeting, and you'll put a resolution to the members which will either set out the amendments, so for example, delete clause 3 and replace it with this new wording. Or if you're making quite extensive amendments, you may put a resolution to the members to adopt a new constitution in substitution for your existing one. Now, unless your constitution provides otherwise, the members must approve the resolution by a 2/3 majority. And again, where you need the Charity Commission's consent, those changes will take effect through the Charity Commission scheme. However, before making that scheme, the Charity Commission will want the members to have approved the amendments as well. So going for a scheme doesn't avoid the need to get your members to agree. If you are a charitable company, the resolution to amend your Articles of Association will be taken by way of a special resolution passed by the members. Now, this means that it must be passed by at least 75% of the members present and voting at a general meeting or an AGM, or 75% of all of your members if you're using the written resolution procedure. Now, as with an unincorporated association, the changes can be set out in the text of the resolution, or again, if extensive, you may find it easier to adopt a new set of Articles of Association in substitution for your existing articles. Now, finally, for CIOs, the resolution again must be passed by your members. If you are what's called a foundation CIO, this is where your trustees are your members. And in that situation, you have a little bit more flexibility because the trustees can designate any of their trustee meetings as a members meeting and then pass the resolution at that meeting itself. But it is really important that the decision is taken by the trustees in their capacity as members for a foundation CIO, rather than just as part of a normal trustee meeting. If you're an association CIO, that's where you have a broader group of members. That decision to amend the constitution must be taken by the members. Now, as with a company, the resolution must be passed by a 75% majority, and it can be passed at a meeting or by way of a written resolution. So you've amended your governing document. What happens next? So all registered charities will need to notify the Charity Commission, and you do that through the online service, which you log into to file your annual return. If you are a charitable company, you will also need to file a copy of the members' resolution and the new Articles of Association at Companies House within 15 working days of the resolution taking effect. And you may also need to notify another regulator if you have one, such as the Regulator of Social Housing. Now over to Hannah for a little bit of a recap.
Thanks, Amy. Okay, so if we've seen, there are lots of different changes that you can make to your governing document and lots of things you need in your governing document to begin with. I think what we'd like to emphasize here is that some of the changes that you may wish to make to your organization may very obviously feel like changes to your governing document, like changing the purposes, and others are still changes to your governing document, even if they don't necessarily feel that way. For example, we want to change the charity's name. That's still reflected in your governing document, and that change will need to be made. So we just wanted to flag that to you. On the slide, there are some examples. Chris has already touched on several of common changes to your governing document. So as well as changing the charity's name, it may be changing the quorum for trustee meetings, which, as Amy has explained, the quorum is the minimum number of trustees required to make a decision. And depending on changes to your organisation, it may have expanded, it may have reduced, the way that trustees are appointed may have changed. Quorum needs to reflect that as well. And there is, again, a recommendation from the Charity Commission that quorum should be a minimum of 1/3 of the total number of charity trustees plus one. For example, if you had 10 trustees, the quorum would be 4. So that's always worth bearing in mind as well. Purposes, again, I know we have discussed several times, but just to reiterate the point that Chris made earlier on, that particularly if you are an incorporated charitable organisation, you cannot make even very small changes to your objects without Commission consent. You can change one word, you can change it to, as Chris has said, to sort of make language gender neutral or to change the tone of it. Even if they're substantially the same, if you're an incorporated organisation, you do need Commission consent. Finally, just to flag the point about holding trustee meetings remotely. This is something, as you can see from our webinar today, that the world has absolutely moved ahead on, and in the last couple of years, it's become very normal for us to hold meetings and conversations remotely and via video link or via the phone. During the pandemic, the Commission actually put in a policy of adopting a flexible approach to how charities held their meetings. And they said that regardless of what was in the charities governing document, they would allow charities to hold meetings remotely so that they could continue to operate in difficult circumstances. That policy is actually now stopped. It stopped earlier this year. And so what we'd recommend is that everybody takes a look at their governing document. Some explicitly allow for remote meetings, some may explicitly prohibit remote meetings, some may be silent. And what you need to ensure is that you're able to hold those meetings however you hold them. They might be part in person with some people dialing in or similar, but you do need to make sure that your governing document allows you to hold meetings in the way that you operate. As Chris said, you need to look at your document every so often and say, does this reflect what we actually do and how we actually operate? So just to wrap up, key considerations for making changes to your governing document. What does your current document say? What does it allow? What limitations are in place? And what processes does it set out for making those changes? As we keep banging on about, what's the legal structure of your organisation? As you can see, that really does make a difference as to when you may need to approach the Commission, if at all, who else you may need to notify, and the processes you'll need to go through in order to get those alterations made. And then finally, the nature of the change being contemplated. Is this something you can do yourself? Is it administrative? Or does this really go to the root of what you do as an organisation and therefore need a bit of engagement with the Commission on that point? I'm now going to pass over to Chris, who will be letting you know what the changes to the Charities Act may be.
Thanks, Holly. So I think I said at the beginning that there are some changes to the rules that we've talked about. Now, the good news is, as I say, these changes aren't going to come into force until October or November, probably next year. So everything we've said today is still relevant, at least for another 12 months in terms of how you might want to go about writing or changing your governing document. And I think there's no really good reason not to hold off making those changes and doing that under the current rules. And as I'll explain, I think it probably actually is sensible to make those changes before the new rules come into force next year. Why are the rules changing? Well, as we've seen, it's complicated. It's not straightforward. There's a lot to try and get your head around in terms of what changes you can make yourself, what changes do you need to involve the Commission with. Does it matter if I'm a corporate charity or an unincorporated? Yes, it does. So the idea was to try and simplify all of this and to try and make a single way of doing this that applied to every charity, regardless of its legal form, which is, you know, a good idea. But I think there are some issues with the way in which the changes have then unfolded. So just to sort of give you a heads up of what's changing and why it might be a good idea to make any changes you're thinking about in the next 12 months. I talked about the regulated alterations regime if you're a corporate charity. So those changes that you must get the Charity Commission's consent for, because they are regulated alterations. So that's changing your purposes, the provisions affecting property and what happens if the charity is wound up, and if you want to change anything to do with trustee benefits. We will still have a regulated alteration regime, so there's not going to be any change in having to go to the Charity Commission to get their approval, but the Charity Commission is going to adopt a new test in deciding whether or not to give consent to those changes. And under that new test, the Charity Commission will, if they receive an application from you to make any changes, particularly in relation to the objects, will say, well, what were the purposes of the charity when it was first set up? And what is the desirability of making those changes? How close to the original purposes are they? And what is your reasoning for making those changes? Now, at the moment, the law is actually silent as to what the Charity Commission needs to do when they look at applications for making regulated alterations. I think the Charity Commission is still working out what its approach is going to be, but it seems to me it'll be much easier or more easy to get those changes through under the current rules than looking at what the Charity Commission might do in terms of that new statutory test. I think we'll need to wait and see how the Commission approaches this, but I think it is actually going to be a slightly stricter test than it is at the moment. So then moving on to unincorporated charities, most of the model governing documents and modern governing documents that you see for unincorporated charities do include some sort of provision to enable amendments to be made. Usually there is what we call some form of express power of amendment that will set out, yes, you can amend this governing document, these are the things that you can amend, and this is how you go about doing it. But there will always be things, I think, that if you want to change, you will have to go to the Charity Commission to get their approval for, particularly if you're a larger charity and you want to change your charitable purposes. And as we've seen, the way the Charity Commission does that is to make a scheme. And so I think that is something that's not going to change. And again, what is changing though is the sorts of things the Charity Commission will take into account when making their decision as to whether or not to allow that change to go ahead. So it'll be the same test that I mentioned for corporate charities. And as always, what the Commission will do is make sure that the way in which the objects are drafted still provides an exclusively charitable purpose. What you're not trying to do is to try and change the object, say, well, actually, we want to do all these charitable things, but we'd also like to do these things which aren't charitable. You're never going to get that change approved, because charities have to have exclusively charitable purposes. If you don't then have an express power of amendment, so particularly older charities, older constitutions, then you'll need to rely on the provisions in the Charities Act. And as we've seen, I'm afraid the regime is fairly complicated. There are different sections in the Act that apply in different circumstances, and it's quite difficult sometimes to navigate through that. The current rules, though, are fairly straightforward for small charities, so those with income of £10,000 or less. As we've seen, it's possible to change those objects if the trustees are comfortable that that's the right thing to do. And there's also an existing statutory power for the trustees of unincorporated charities to be able to change some of those administrative provisions, so provisions around quorum and trustee appointment and things like that. But if you're a charity with members, you do still need to get that approved in a members meeting, and that needs a 2/3 majority vote. What is going to change next year is a new statutory power for trustees of all unincorporated charities that will allow you to amend your governing document regardless of what is in your constitution. And that's going to replace the existing rules, and it's quite a radical change. But you'll still need to get Charity Commission consent for certain changes. So that's, again, changes to the objects, changes to what happens to the charity's assets if the charity's wound up, changes to trustee benefits if you wanted to make payments to trustees and things like that. And then, as I said before, changes if you hold that special type of property called permanent endowment. And Charity Commission consent will also be needed if you have, for example, a local authority or another organisation that has the right to appoint your trustees, unless that appointing body has just simply ceased to exist. So there are going to be some changes there. And under the new changes, the thresholds are higher than those that currently apply. So again, I think that's why I'm saying it's going to be better if you can make those changes in the next year if that's what you're looking to do, because the threshold is going to change. We said earlier it was a 2/3 majority. That's going to go up to 75% as it is already for companies. I'm going to stop there because I think it's more important that we leave lots of time for you to ask any questions, and if you've got any specific comments or thoughts what we've said and what other information you would find helpful, because I think we would love to be able to help NCVO in provide as much of a resource as we can.
Brilliant. Thank you. I think we can probably stop sharing for a minute, and we can also stop the recording as well, please, Sophie. Excellent. So you can see all of the panelists now as well.